Today I'm here to talk to you about the reinstatement of regulatory arrangements for the investigation and prevention of trade distorting activities in Chile. Supreme Decree number 1314 of the 28th of December 2012 was published on the 22nd of March 2013. The decree reinstates the regulatory framework which consolidates the regulation of trade distorting activities under one regulatory body. The organisational structure established by this regulation makes the National Commission the body responsible for hearing applications for investigation on the application of anti-dumping, countervailing and global safeguard measures, with the central bank acting as the technical secretariat. The investigations undertaken by the Commission will be made in accordance with the provisions of Law Number 18,525, the Agreement on the Implementation of Article 6 of the General Agreement on Tariffs and Trade 1994, or the GATT, the Agreement on Subsidies and Countervailing Measures, and the Safeguard Agreement, all of which are part of the Marrakesh Agreement. There are two classes of investigation which can be brought before the Commission. The first is safeguards, and the second relates to dumping and subsidies. In both cases, a common set of rules apply, with specific rules applying under certain circumstances, depending on the type of investigation in question. In this next section, I'm going to talk to you about the provisions that are applicable to all investigations. An investigation may be initiated unilaterally by the Commission or at the request of an interested party. In the latter case, the procedure will start when a written application for an investigation has been submitted by the interested party. Such an application must be submitted by a branch of domestic industry or on behalf of or by a representative association of the industry that is considered to be harmed or threatened by serious harm in the case of safeguard measures, or damage in the case of anti-dumping or countervailing measures. Within 5 working days of receiving a formal request for investigation, the Commission shall provide a statement of reasons whether an investigation will be undertaken. This statement will be published in a notice in the Official Gazette. Investigations are deemed to have commenced from the date of publication of a notice of investigation in the Official Gazette. In special circumstances where it's considered warranted, the Commission may unilaterally initiate investigations under the regulation and, in so doing, will apply the same procedures for investigation as an investigation that was initiated at the request of an interested party. In this next section, I'm going to talk to you about investigations regarding safeguards. Safeguard measures consistent with an ad valorem tariff surcharge may be applied if the Commission has determined that, as a result of unforeseen developments, including tariff concessions imposed by Chile, a product is being imported in such increased quantities, absolute or relative to domestic production, and under such conditions that it causes or threatens to cause serious injury to the domestic industry that produces the like or directly competitive good. It is not possible for the Commission to make a determination of serious injury or threat of serious injury unless the investigation demonstrates, on the basis of objective evidence, the existence of a causal link between increased imports of the product under investigation, either in absolute terms or relative to domestic production, and serious injury or threat of serious injury. Ample opportunity will be provided during the investigation for stakeholders to present their evidence. Before adopting its final determination, the Commission will hold a hearing with stakeholders. Also, an investigation may not extend for more than 90 days from its commencement. In critical circumstances where delay would cause damage difficult to repair to the domestic industry of the like or directly competitive good to the imported product, the Commission, of its own volition or at the request of another party, may recommend to the President, through the Minister for Finance, the application of a provisional safeguard measure consisting of an ad valorem tariff surcharge. The provisional safeguard to be adopted will apply from the date of the publication of the Supreme Decree in the Official Gazette that imposes the safeguard until the publication of the final decision determining the matter ineffective or applying a definitive measure. In either case, the duration of the safeguard measure may not exceed 200 consecutive days. If, at the completion of the investigation, it is not possible to determine, in the opinion of the Commission, whether to establish a definitive safeguard measure, the Commission will issue the appropriate resolution to end the investigation, and a decision will be communicated to the Minister for Finance in order to have the extract published in the Official Gazette. In either case, the period for the application of the definitive safeguard measure shall not exceed 2 years from the date of publication of the decree that established it, unless extended in accordance with the requirements that the same decree states. In cases where provisional measures were implemented, the time frame is within 2 years, counted from the publication of the decree that established them. Persons affected by provisional measures during investigations for the application of safeguard measures may request a refund of the total amount paid if the investigation resolved ultimately the non-application of tariff surcharges. Similarly, persons affected by provisional safeguard measures may request partial reimbursement in cases where their final liability is less than the amount that should have been paid while on an interim ruling. In this next section, I'm going to talk to you about investigations regarding dumping and subsidies. In relation to investigations regarding dumping and subsidies, anti-dumping or countervailing duties consisting of ad valorem tariff surcharges may apply if the Commission has determined that imports of a product are dumped or subsidised respectively, and as a result of dumped imports or a subsidy, damage is caused to the domestic industry that produces the similar product. A product is deemed to be dumped when it is imported at less than its normal value. That is to say, when its export price, when exported into Chile, is less than the comparable price for the product when destined for consumption in the country of origin in the course of normal commercial trade. The Commission may recommend the application of an anti-dumping duty if the Commission determines that imports of the product under investigation are dumped and that as a result of this, damage has been caused to the domestic industry. The Commission may also recommend the application of a countervailing duty if the Commission determines that imports of the product under investigation is the subject of a subsidy, that the subsidy is specific to an enterprise or industry group of enterprises or industries, and that as a result of these issues causes injury to the domestic industry. In this next section, I'll talk to you about the development of the investigations. Regarding the development of investigation, within 5 days of the inception of the investigation, the Secretariat will send the investigation or the questions that the Commission has determined in order to require background information on the case to exporters or foreign producers, importers, and any other person that the Commission determines that relate to the product or products being investigated. During the investigation, there will be ample opportunity for stakeholders to present evidence. Before adopting its final determination, the Commission shall inform all parties interested in research about the essential facts on which it has based its determination, that is, in its decision whether to recommend the imposition of the definitive measure. Along with communication of the essential facts, the Commission will report on the place, day, and time for a hearing to be held with stakeholders in which they will be given an opportunity to express their opinions. Determinations regarding essential facts, information and evidence submitted by other parties and expose what they consider to be relevant. The hearing will take place at least 15 days after the essential facts are reported, and interested parties may participate if they so requested in writing with a minimum of 3 working days following the date of the publication. An investigation relating to anti-dumping and countervailing measures shall be completed no later than 9 months after its inception. In this next section, I'll talk to you about the application of the measures. Within 60 calendar days from the start of the investigation, the Commission may make a preliminary determination of their results. If the preliminary determination of the Commission indicates the existence of dumping or subsidisation and consequent damage, it should be noted in a report and may be recommended to the President through the Minister of Finance the application of provisional anti-dumping measures. These are applied for the shortest period possible related to the existence of the condition for their adoption, and in any case a maximum term that doesn't exceed 4 months. If at the completion of the investigation the background information available permits the Commission to determine that it meets the requirements for the application of a final anti-dumping or countervailing measure, the Commission will issue a decision based on this regard, and in addition to establishing this final determination, shall recommend the implementation of the measure in question. If, prior to the completion of the investigation, the information available does not make it possible, according to the Commission, to establish the final anti-dumping or countervailing measure, the Commission will issue the appropriate resolution to end the investigation, and the decision will be communicated to the Minister for Finance for the purpose of having it published in summary form in the Official Gazette. The anti-dumping and countervailing duties will have a maximum term of 1 year from their publication in the Official Gazette. These measures remain in force only as long and to the extent necessary to counteract dumping or subsidisation, which is causing or threatening to cause the injury. If the Commission terminates an investigation without making a recommendation on dumping or countervailing measures, a restitution will be made of any duty paid as a result of the temporary measure. Thank you for your time today, and we hope you found this useful.